Straight ahead on Law and Crime Daily. A date is set for a new penalty phase in the trial of Scott Peterson, convicted in 2004 of killing his wife, Laci.
Plus, legal troubles surrounding 3 rap artists. And actor Johnny Depp suddenly gives up a movie role because of his own court matters.
Also, a verdict in the trial of an Iowa mother accused of murdering her child. And then,
he was Hamilton County prosecutor. He's got his own law firm and everything. He's only 55 years old.
a touching interview with a woman who comforted a dying attorney. Police are still looking for the person who took his life.
Law and Crime Daily covers court cases from coast to coast.
Sentenced to death for murdering his wife Laci and their unborn child on Christmas Eve in 2002. The state Supreme Court ordered Peterson's death penalty overturned and his conviction re-examined, all because of possible misconduct by a juror. Peterson appeared virtually in court and waived his right to a speedy retrial. The judge indicated Peterson's penalty phase could be retried in January 2021. Mark Garagos represented Peterson at his first trial and believes that people lied during the jury selection process in order to get picked.
I called at the time stealth jurors, meaning jurors who were lying and had an agenda to get on here. And frankly, every single one that we identified was lying to get on here to convict him. We caught a couple of them in real time. This juror, we did not. And she is obviously a troubled young woman. And the subsequent investigation showed that when she filled out the forms, she had absolutely lied about the fact that she had had a restraining order and that she had had an encounter with another woman. And that was exactly what another juror who we had found and exposed during voir dire had done. And then later, that other juror had admitted that she was lying to get on there to fry Scott. Her words, fry Scott. So this is a significant issue. Obviously, I've maintained for close to 17 years that Scott is innocent and that this was a mob verdict, and hopefully now he'll get the justice he deserves.
Okay, this is a big case. Everybody has an opinion. Terry, let's start with yours. The issue of venue appears to remain on hold for now because this case is bouncing back and forth between a couple of counties. Wouldn't they want to straighten out the venue issue before picking a date for the penalty phase of the case?
You know, that would be the logical order of issues, Aaron, but I think whether the case is in San Mateo, like Peterson wants, or whether it's in Stanislaus County, as the prosecution is saying they want, Peterson really has the right to assert his, speedy trial, and regardless of what the venue is. So under the 6th Amendment of the U.S. Constitution, we know he has every right to do so. So they can sort of skip the order here and determine one issue before they actually determine the venue issue.
So, Brian, January 2021 seems like an awfully fast date for the penalty phase of a case after a defendant waives his right to a speedy trial. January is pretty speedy.
Yeah, it seems like it's right around the corner. Of course, everyone has the right to a speedy trial, and only the defendant has the ability to waive it. And so what I think the judge is trying to do here is saying, you'll waive it, but not too long. We don't want that right to extend past a breaking point.
So, Terry, how serious are the juror issues in your opinion here? Should a judge order an entirely new trial because of these issues that Mark Garagos talked about? New trial, start to finish, and not just a new penalty phase?
You know, Aaron, that's also a very difficult question because I do think he's guilty, but it is a serious issue. If, in fact, that juror lied about the fact that she had a legal proceeding. This was juror number 7. And she lied because she wanted to get on the jury and she wanted to, quote unquote, fry Peterson. That would be enough, frankly, to send it back for an entirely new trial. So while people think that Peterson is guilty, he did not get a fair shake there. And I think it might be right to get a whole new trial, as much as I don't want to say that.
Okay, so Brian, take off the public defender hat, put on the judicial robe here. Just for purposes of this show, should there be a new trial?
There should be a new trial, and the reason for it is not because of the defendant, but because of the system. If we are going to uphold this system of being tried by a jury of your peers that are fair and impartial, that has to apply to the guilty as well as the innocent, and to ensure that the system works the way it's supposed to.
Due process is very important. I agree with you there. Rest of the opinions we may differ on, but I agree on that. Actor Johnny Depp announcing a resignation from his Warner Brothers role on The Fantastic Beasts while promising a legal appeal. Depp posted this letter to Instagram saying allegations raised against him were, in his words, false. Depp sued a British newspaper for calling him a wife-beater, but the newspaper recently won. He called that legal judgment surreal. Depp and his ex-wife, Amber Heard, have been locked in legal battles of their own leading up to and surrounding their divorce. Heard says Depp abused her. Depp says Heard abused him. And let's turn now to Brian Buckmire with several legal issues surrounding rap artists, or in the case of Tekashi 6ix9ine, their kidnappers. Brian?
Hey, Aaron, so a man with gang ties has been sentenced for kidnapping rapper Tekashi 6ix9ine. Anthony Harv Ellison will spend 24 years in prison after he was convicted of kidnapping, racketeering, and violent assault. Ellison is said to be a member of the 9 Trey Gangsta Bloods. Rapper Tekashi 6ix9ine testified that Ellison and another man kidnapped him at gunpoint back in 2018. The rapper, whose real name is Daniel Hernandez, said he joined the Bloods but was never initiated. He testified that as a part of a plea deal to allow him to have a lesser sentence in his own case. Lawyers for one of the men charged with XXX Tentacion's shooting death are trying to get evidence thrown out of the case. Michael Lil Boatwright is accused of shooting the rapper and trying to steal his Louis Vuitton bag that had $50,000 of cash inside. Boatwright attorneys say that he was not mentally competent and he was under the influence of marijuana when he spoke to the detectives. XXX Tentacion's, whose birth name was Jashish Offroy, was killed in his BMW after he withdrew cash from a bank. Boatwright and 3 other men are charged with first-degree murder. A trial date has yet to be set. A rapper charged in the double murder of his own friends is now being sued for millions by the families of the alleged victims. YNW Melly, whose birth name is Jamel Demons, is accused of shooting 2 men in his car, staging the shooting to look like a drive-by, and then dropping the bodies off at the hospital. Melly was known for working with Kanye West and had released a music video called Murder on My Mind. The lawsuit claims the rapper killed his 2 crew members after a dispute about money. The families are asking for a jury trial and damages in the millions.
Brian, thanks a lot for the updates. And still ahead on Law and Crime Daily, a judge admits a mistake in the case involving one of the 4 police officers accused of murdering George Floyd. But first, a verdict from a judge in the case of an Iowa mother. There is a verdict to report in the case of an Iowa mother accused of murdering her 5-year-old daughter. This one's a little bit tricky, though. Prosecutors claimed Kelsey Thomas strangled Chloe Thomas with her own pajama pants. A jury back in March acquitted Thomas of child endangerment resulting in death, but was hung on first-degree murder. Prosecutors moved for a second trial, and Thomas chose to be tried by a judge rather than a jury. The judge convicted Thomas of a lesser count of involuntary manslaughter. That carries a possible sentence of up to 5 years in prison. The judge's decision was based in part on this so-called confession from one of Thomas's police interviews.
She jumped in her bed, and as I was coming, I came into the room, and she had jumped out of her bed, and I tried to grab her arm, and she slipped out of my arm, and I ran out of her bedroom. I grabbed the pants, and I just went like this, and I pulled. She was really quick. She was, I mean, like I said, I tried to grab her arm, which stopped her, and then she turned, got my arm out, or got her arm out of my hand. So I grabbed the pants, and I swung over her, and then when I pulled, I don't know, honestly, if I twisted, or, I know she had turned around. And I started to fall backwards. So I picked her up and I laid her on her bed, and I held her down and I told her, I was like, you need to go to sleep.
The judge seemed to agree with the version of events that the prosecution laid out during closing arguments, but held that the defendant simply wanted Chloe to take a nap so she herself could rest. In other words, no intent to kill and no premeditation.
The defendant told Chloe, you're going to take a nap or I'm going to beat your ass, because she wanted to make sure she could rest. Chloe, like any other normal 5-year-old, didn't want to take a nap. So she ran away from that bed. And what did her mother do? She took those pajama pants, she threw them over her, pulled back, and strangled her with those pajama pants. In Chloe's last moments on this earth, she would fight for her life, staring at her own mother. We know that the defendant intended to do this act. She intended to cause injury to Chloe Chandler. There is no other intent when you take pajama pants and use them in the way that she did.
So the facts the judge agreed with here, Terry, but not necessarily the intent thing. The judge said this killing happened in a fit of anger and frustration, but not with malice aforethought, or in other words, without premeditation. That makes a huge legal difference.
It does, and I can see where the judge may have gotten to manslaughter, but I think what the judge is forgetting is that the defendant here had multiple explanations, and to me, that means consciousness of guilt. And the other issue, at least based on the research that I saw under Iowa Code 707, they could have had first-degree murder charges here based on the fact that it was a parent or guardian who killed a child while committing an assault and death occurs. So there's that, and that wasn't asserted here. That wasn't in any way, shape, or form part of the evidence, and I think we could have relied on that to get this first-degree murder charge.
So you're suggesting the prosecution should have gone after this a little bit differently. Brian, the judge also believed that Kelsey Thomas was just trying to scare Chloe into taking a nap. In other words, no intent to kill, contrary to what the prosecution argued. So what kind of parent ties something around a 5-year-old's neck to scare a 5-year-old into taking a nap?
So again, this is the belief of the judge, who is both the arbiter of the law, but also the finder of fact. And now that Kelsey Thomas is guilty, I guess legally speaking, we have to say that she did this. But to answer your question, Aaron, the type of parent who does that is one who's going to find themselves behind bars for quite some time. It's not one that I think we allow to walk among society with the rest of us.
Yeah, I mean, the top penalty here is potentially up to 5 years. It's a drastically lesser penalty under this count for which Kelsey Thomas was convicted versus what was charged. Terry, back to you. The judge dismissed Kelsey Thomas's claim that Chloe hung herself on a dowel rod in her closet that was about 2 feet taller than Chloe was. The defense hung on to that claim till the end almost, but the judge called it absolutely unbelievable.
Well, it was absolutely unbelievable because it was just one of the explanations that Thomas asserted here. And physically, it's not even possible to do that. And so when you have a defendant who provides all of these different types of explanations, I do think it is very difficult to believe anything the defendant said. And again, I go back to the fact I think she should have been charged and convicted with first-degree murder.
So, Brian, back to the legal tactic here. Did the defense choose the correct tactic by asking the judge, not a jury, to try this case a second time?
Me specifically, I am not a fan of bench trials. I go jury all the time. I think this was a mistake, especially when you look at the previous trial. And the reason why I think this is a mistake is because with a jury, you can say, hey, this is what they're arguing. They haven't proved it. But as we've seen here with the judge can find a way to say, I validate this testimony, but not this testimony, maybe some of this testimony, and then figure out a way to involuntary manslaughter. And I don't want that as a defense attorney.
It's a conviction, but on a much, much lesser count. So maybe the defense is popping corks here to celebrate. We don't know, but it's possible. And coming up after the break here on Law and Crime Daily, we take a closer look at 911 calls and the police shooting death of Walter Wallace Jr. and police. Police in Cincinnati are looking for leads after
personality, along with this tagline, which was "Stop by the man, call the man." Now, this is the area where people have laid flowers on the spot where Adams was hit and killed while riding his bike early Sunday morning. He was an avid cyclist, a husband, and a father. Anna Lear heard what she described as the sound of glass hitting glass. She ran outside and found Adams on the ground and a teenager calling 911.
I just sat out there with them until the ambulance came. The kid talked to the ambulance. I sat there and talked to, well, his name's Steven, but I talked to Steven and just kept telling him to hold on. The ambulance was coming. He wasn't talking, but he was moving his eyes and his head, but he was bleeding. He had his helmet on. He had full gear, biking gear and stuff like that. So, but he wasn't. He wasn't able to move until he heard the ambulance, and he tried to roll over and get up.
There were a couple of surveillance cameras mounted on a building near where this crash happened, but police have not said whether or not they captured any images of the crash. Right now, there are not any leads. I'm Angenette Levy for Law&Crime Daily.
The Minnesota judge overseeing the trial of 4 former police officers accused of murdering George Floyd has set the record straight after making a mistake in a prior ruling. The judge recently agreed to try all 4 defendants together in a televised trial. The judge filed new paperwork admitting he overlooked a so-called Rule 9 disclosure, which outlined the defense tactics of defendant J. Alexander King. The judge clarified that King does not seek to blame Derek Chauvin and that King's strategy does not suggest he will be antagonistic to Chauvin at trial. When we come back, the police shooting of Walter Wallace Jr. Family and neighbors called police to break up a chaotic scene. It all ended with Wallace's death, but the 911 calls are helping a community understand precisely what happened. You'll hear those calls next on Law&Crime Daily. And now to the police shooting of Walter Wallace Jr. in Philadelphia. We've spent several times these last several days reviewing witness video and body camera video from the officers who pulled the trigger as Wallace was moving about with a knife. Officers said he was chasing them after they responded to a series of 4 911 calls about an assault. The first call appears to have been a hang-up. The next call came in just 4 seconds later from a neighbor.
Okay, what's going on, ma'am?
I don't know, the people next door fighting. The boy that came back again and tearing up his mom's house and fighting them and doing all kinds of stuff.
Okay, are you okay?
Yes, I live next door.
Okay. So we'll get police out there. That is apartment B, right?
Yes, he said, yes, somebody asked me to call the cops right away.
Okay, I got you.
That was the second 911 call for help. The third call came in 18 seconds later from Wallace's sister.
I'm the daughter to my mother and my father, and my brothers, they called the cops earlier, and the cops is not doing nothing. He's over there hitting my mother and my father, and I'm always in shouting.
How old is your brother?
He, oh my God, he's 27.
Any weapons involved?
No, but he got a case of, he on probation and everything. He got a case for being violent and everything. He got a whole record.
Okay, does either your mother or father need a medic out there?
Yes, my dad's saying that he's about to faint.
Okay.
And my mom's blood pressure is all the way up.
All right, police will be en route to help them out, but stay on the line for medics, okay?
And they in there screaming, so I don't know what's going on over there. I just asked somebody.
Listen, ma'am. 6124 Locust, apartment B.
Yes.
Police are going to help your parents out, but stay on the line for medics, okay?
Okay, thank you.
40 seconds after that third call came this fourth and apparently final call. Here, the chaos becomes apparent. The audio is unclear, but we've silenced a few small sections which may contain profanity.
Philadelphia Police 174. Hello? 6124.
Police and paramedics were dispatched as those calls were in progress. Officers were advised to use caution because of what dispatchers called the ongoing domestic situation. Brian, we've talked a lot about the witness video and the body camera video. What do the 911 recordings most help us understand?
I think they're going to help us understand the defense's argument here. If this case does get indicted and go to trial, I would expect that sister especially to be the defendant's first witness on the stand. She paints the picture of elder abuse, an individual with a probation and a criminal pension for violence. And when the officers are arriving, that is their mindset. That's what they're going into. And I think it's going to be very damaging for the prosecution and great for the defense to kind of excuse why they showed up in the way they did.
And again, remembering this time things are a little bit flipped. It's the defense for the police officers, assuming that this case may go to trial. So, Terry, I'm hearing phrases here, just writing down as I watch and listen to these again. It's someone with a record, there's an assault in progress, ongoing domestic situation, and then officers show up and there's a knife immediately produced when the subject walks out of the house. So is it reasonable for officers to go into a situation like that fearing the worst?
Well, you know, I think it is reasonable for officers to have a good understanding of what the situation they're facing, because they have to be prepared to respond accordingly. The problem here is the individual had a knife. He did not have a machine gun, and I think that they used deadly force when they could have just tried to stop him from what he was doing. One other thing I'll say, Aaron, here, and I just heard it this time when I listened to the recording, the 911 operator said, does he have a weapon? And the sister thought that, or the daughter thought that she was saying, does he have a record? And that's how they went into the whole issue of the record. So I don't think the police knew that there was a weapon on the scene. In any event, I think that it was just a knife. So I think it was just overkill.
Yeah, in the final moments when he came out, that's when they noticed the knife, I should say. We're out of time here on Law and Crime Daily. We'll see you next time to discuss justice in America.